Could somebody move that those minutes be accepted? Moved by Mayor Russell, thank you. Seconded by, couldn't quite see, someone from Grey.
Gibson.
Councillor Gibson, thank you, Alan. All in favour, aye.
Aye.
Against, no, carried. Turning to the minutes of the 17th of February, any questions or comments as to the accuracy of those meeting minutes? Somebody move that those minutes be noted as a true record of that meeting. Moved by Mayor Gibson, is it? Seconded by
Lash.
Oh, sorry, Lash. Sorry, Helen. Seconded by Mayor Russell. All in favour of that? Aye. Against? No, carried. Thank you. Then any matters arising from either of those meetings, the 10th of February or the 17th of February? No matters arising. Thank you. Moving then to the reports, the update on the appeals from our principal planner. Thank you.
Oh, sorry, just struggling with my video. Thank you. My apologies, Mr. Chair and committee. So just a quick update. We had quite a number of people who joined as Section 274 parties, or what's known as Section 274 parties. Most of those lodged were people who were already appellants, and they were just registering their support, opposition or interest in other appeals. But we had 12 additional appellants. It's 11 listed in your paper, but we had a couple of, 274 parties who didn't lodge their notices with the TTPP, but we got them from the court. And so I just add there's also a new 274 party as Mr. Scott, who's got an interest in the Ridgeline developments or investments appeal. So we're just well through now doing quite a lot of the appeals administration, I guess, which is unfortunately quite a lot of work for sorting out all of the process. But there's nothing really, I guess, other than to update you that round of process is complete now. So just really happy to take any questions that the committee might have.
Questions? Perhaps if I could just ask a question, Lois, the actual background work that you're busy on, what does that consist of?
So for all of the appeals, just as we've done for submissions, we had to break them up into appeal points and assign them to topics. And so that's result, obviously that's quite a lot of work. And then all of the 274 notices similarly have to be assigned to each of the appeal points. So many hours of data entry, I think it would be fair to say. It's sort of tedious administration, but really important because it enables us to group all of the appeals so that we can run the mediation really efficiently. And I guess that's the end goal. And we're able to produce reports easily, which show which appeals, their status, all of that kind of thing. So all of that's held in the database called Spoken.
Yeah, thank you. Any other questions from committee members on where we're going with the appeals? No. I'll move that report be received. Someone to second that. Thank you. Thank you, Paul Medrick. All in favour of that? Aye.
Aye.
Against? Carried. Thank you.
Well, through the chair.
Yes, yeah. Sorry, Paul.
Yeah, I just wanted to comment on that. That now that there is a third of the plan that's fully operative now, it'd be good to get a press statement out about that to let people know if that's the case.
Yes, and to be somewhat explicit as to which sections are fully operative. Yes. Yeah. So if you could pick that up, please, Joe. Yeah. A good point. Thank you. Moving on to the next item on the agenda, a verbal update on the mediation process. I guess Joe might lead in and then we'll hear from Alice.
Thank you, Mr. Chair. I will just hand over to Alice Barham
Thanks, Joe. Yeah, so hello everybody. Just a very quick update. We had quite a big deadline yesterday in terms of the appeal process. So we had to file with the court a case management memorandum, which set out basically how we propose to deal with the mediation process. It provided to the court the information around the topics and all of the work that Lois has been doing in the background to allocate the various appeal points to the various topics. And then it set out a proposed timetable at a very high level in terms of how we will work through the mediations for each of the topics. So it was a really comprehensive document. It was circulated to all of the parties involved in the appeals for them to have an opportunity to provide feedback. And we did receive a lot of really good, helpful feedback. So there was a lot of input from the appellants and the 274 parties. And we now just have to wait and get some directions from the court, which will hopefully confirm the approach that we've proposed in terms of moving into this next stage, which is mediation. The other thing perhaps just to highlight is that one of the first steps that we will have to take in this process is to consider whether it's appropriate to strike out any of the appeals. And it's a really difficult balance to strike, sorry, you find a different word, but a difficult balance to strike to decide whether we do apply to strike out appeals. And the only circumstances in which we would do that is where it's really clear cut that the appeal has no jurisdictional basis to have been filed. So if somebody has tried to appeal a part of the plan that they didn't submit on, that they haven't been involved in, that they just don't like, we would look to strike that out. And the reason why we do that is because this process is constrained for a reason. And if we have to deal with all of these things that people don't have scope to deal with, it's just going to add a whole lot of additional time and cost to the process. So we will be working through that in the next few days. We're working with the parties at the moment where we think that they don't have jurisdiction for their appeals to try and get them to explain to us why they do have jurisdiction. But if we can't land that, then we will need to make some applications for strikeout for the blatant ones where there's just simply no scope to deal with them. It's not only an issue of time and cost for us, but at the end of the day, when the court comes to make a decision, if the court doesn't have jurisdiction to grant the relief that a particular appellant is seeking, because they didn't have any ability to make that appeal in the first place, then the court won't grant the relief. So we will have potentially wasted a whole lot of time and energy in trying to resolve something with an appellant, and then there's no ability for the court to grant it. So that's why we have to go through this exercise of making sure that everyone's appeal is valid in the first instance. That we've got a deadline to sort that out, which is by the 2nd of April. So that's sort of the next big step in the process for us. And then the court has indicated to us that they have a commissioner available who is willing to spend some time on the West Coast and conduct all of the mediations on the West Coast, which is really great. The court is, I don't know who it is yet, but they've got someone. The court is currently looking into venues for mediation, and they have said that they don't need our help with that at this stage. So I'm working closely with the court registrar to offer our services if she needs them. They have also indicated that if there are any hearings required, the hearings will need to, or the court's preference is that the hearings occur in the closest courtroom to where the conflict is. So on the West Coast, that will be either in the Greymouth courtroom or in the Westport courtroom. I think those are the only two courts on the coast. And that will likely be determined based around the scheduling requirements of those courts and what else they have going on at the times that we need to have hearing time. They are setting aside some hearing time later in October, November for us if we need it, just so that we've got some blocks in the diary, I guess, because the courtrooms across the country are really busy. I think that was all in terms of an update. I'm happy to take any questions on where we've got to.
Questions? Paul Medrick, please.
Thank you. Alice, did we establish whether or not they will allow the hearings regarding sites and areas of significance to Māori to be held at the marae?
I've indicated to the court that the marae is a venue that's available to them if they'd like to use it. But they were quite clear that they didn't need our help at this stage in determining venues, and that's a matter for them to determine. I guess I can understand why we would want those topics to be heard at the marae, but it may not be considered a neutral ground for the other parties involved in it. So I've mentioned it to the court, and it's now in the court's hands to decide that.
Okay, thank you.
Mr. Chairman, Daryl here. Just in relation to the appeals that may be considered to be struck out through lack of legal standing, I just want to ask the joint committee members here today whether that's something they want staff to enact and decide and follow through on, or is that a paper that you would like to consider to come back to you all with the names and the reasons why they're being struck out or recommended to be struck out?
Well, through the chair, if the appeals are being struck out because there's a jurisdictional issue or they have no standing, then I don't see why we need to come back to the committee. That would be something I'd see that would be just left to the staff, the team.
Thanks. Just wanting to test that, Ed, but given that could create some, community reaction, would it be helpful if the staff just provided you with a list for your information of what's being struck out?
Thank you. Alice, to comment, please.
Sorry?
Sorry,
Alice?
Alice, is it appropriate for you to comment on the procedure, the standard procedure in these situations?
Yeah, so as I think was mentioned by the chair, the regional council chair, the question is, do these appellants have standing or not? And it's a legal question that we're happy to make a call on, but I appreciate that the consequence of taking this approach will be public scrutiny. And so it might be that you want to be advised in advance of us making these strikeout applications so that you're aware of what's coming in the community. But as I mentioned at the start, I'm really conscious that this is a public process and it's important that everybody has an opportunity to be heard. And we would only consider a strikeout because it is a legal process where it is really, really clear that the people who have filed these appeals or particular appeal points simply have no legal standing to make those appeal points. If it's a grey area, then I would suggest that we err on the side of just leaving them in, because it's really important that people have an opportunity to be heard. But where it is really, really clear, and where I think that the court will never grant relief because there is no standing, then it's quite an easy decision at that point. So I'm happy to give you notice before we file the applications of who will be affected, so that you're prepared if that's what the committee would like.
Through the chair, I think, Alice, it would be helpful for us to know, as Daryl has raised, but make it clear it is for the legal team, your team, to make those decisions, because it's if there's a jurisdictional issue or a standing issue, it's purely a legal issue.
Yes, yeah.
Paul Medrick had a question.
No, it wasn't a question, Mr. Chair. It was just a comment to say that I don't agree to just leave it solely with the legal team without coming back to the committee, as was suggested. The committee needs to know exactly who's being struck off and why they're being struck off, and the public need to have the right to know this as well. We don't have many appellants, and so where they are being struck off, I have faith in the legal team, of course, that they'll only be struck off for valid reasons, but we still need to convey that to the public and openly.
Alice,
can I just ask Alice to clarify? We're not talking generally about striking out a full appeal, are we? It would just be if some points they've wandered off into things that they hadn't actually have jurisdiction on.
Yeah, I was just trying to rack my brain to think about the different ones that we're looking at the moment, but by and large, it is just particular appeal points within appeals that there is no standing for. So I can't think of, there might be one that is a strikeout in its entirety because the appellant didn't make a submission on the plan and therefore has no legal standing to make an appeal. I think there might be one in that category, but the other few, and we're only talking about a few, are just specific appeal points that would be struck out, or 274 party points that would be struck out, not the entirety of an appeal.
Thank you. Could I just further clarify, if there's a disagreement about whether the strikeout is valid or arguable, does the person or the appellant have a further step to take?
Yes, so the way that it works is that we would make an application to the Environment Court to have the appeal struck out, and then the appellant would have an opportunity to respond to our application, and then in the interest of efficiency, we would ask the court to determine those applications on the papers, which means that they would be determined without the need for a hearing. And so both parties get to have a say on whether or not there is standing for a particular appeal.
Okay, thank you. So turning to the point that was raised, I get the sense that the committee would like to be just kept informed of those decisions, respecting the decision that you can make, but then the information be made available to the committee. Is that the summary for the committee? Paul Medrick, you raised that. Is that how you see it? Yep.
Yep,
Okay.
pretty much.
Yep.
Thank you.
Thank you. Any other comments on that particular, the strikeout matter?
Yeah, Rex, just one from me.
Yes.
Paul raised the point about communication with the public. I assume, Alice, through the court proceedings, if they strike one out, that would then be updated through all of their stuff to then become public information?
Yeah, so all of the strikeout applications would likely be uploaded on the website so that people can see them. I mean, we're trying to be as transparent as possible through this process.
And at which point the courts go forward and do that, we can then follow up with a press release once those decisions are made, correct?
Correct, yeah.
Thank you. Thanks,
Councillor. Any other questions on that update on the process? The Commissioner of...
Just one, Rex.
Yes, please.
If I could just go back to the venues, I would like to totally see them be neutral. Paul's mentioned the Marai, but I don't agree with that. I mean, we need to go somewhere where the public can see there is absolutely no conflicts of interest. So I agree with what Alice has said.
Thanks.
Yep.
I think the point is, Councillor, that it's up to the Environment Court to make those decisions. So I think people hear your comment, but it's not a decision for this committee. Yeah.
Through the chair.
Yes, please.
Councillor Maitland here. I'd support Paul on his request that that information does come back to the committee.
Yeah, the strikeout information. Yeah. Yeah, thanks. Any other questions? Someone else has got their hand up?
No.
No. Okay. There's nothing else on that report. Could somebody move that report be received? I think
that was just a verbal update, so I'm not sure that you need to do anything.
Thank you for that advice, Alice. All right, we acknowledge that. Thank you. Moving on then to the next item on the agenda, the financial reports.
Thank you, Mr. Chair. This is a very standard report. I just update the figures for you and happy to discuss any of those, including the tables. But I would just draw your attention to point 4 in the report, that our principal planner, although capable of many things, can't represent the committee on every single one of the mediations, and so the staff have run a competitive selection process to find another extremely competent planner to represent your positions on the minerals and energies topics. We anticipate that the services will fall under the delegated financial authority that you've given to the Chief Executive of the West Coast Regional Council. So following our process, the Chief Executive has approved and signed that contract. So just to let you know that as we talk through in the positions subcommittee, the minerals and energies topics, a different planner will be involved in those conversations and positions papers and things like that.
Thank you. Any questions on the financial report as circulated? No.
Kai whakaare magic does.
Oh, so, Paul, you had a question. Sorry, can't see that.
Yes, I did.
Thank you.
Thank you. The I expect that the additional planning service that's going to be contracted for this will be someone that's familiar with the West Coast, someone that knows about the nuances of on the West Coast situation, and not someone from Auckland, for instance, has no idea.
That is correct. We've actually contracted with someone who has a property on the West Coast and who was involved in the technical advisory team on behalf of the West Coast Regional Council when we were preparing to notify the decisions version of the plan. So it's very familiar also with the plan and understands the committee perspective, and we would want to end up in the plan. So we're very happy with the choice, actually, with her availability.
Okay, thank you.
Any questions on the tables, any of the figures there? You're all beginning to, new members able to read them and understand what's what, because I'm happy to talk you through any of that at all if you've still got any questions.
I don't see any questions. I think members are now familiar with the table and the outcomes. I think then appropriate for somebody to move the receipt of that financial report, please. Is that nobody's forthcoming? Councillor Webb, thank you. Seconded by, I'll second that from the chair. All in favour of the receipt of that report, please say aye.
Aye.
Against? No, carried. Thank you. We then move to the late item and ask Joe to introduce this, please, carefully.
Yes, thank you, Mr. Chair. You know that I would like to gloss over and not do it carefully, so thank you for that reminder. We have just presented you just last month with the draft budget, and at the time staff made a point of pointing out the uncertainties that are involved in running this appeals and hearings process, because it's out of our hands. It's definitely a process run by the courts and was totally determined by the number of appeals and appeals points and the huge number of Section 274 points actually that we received that we didn't have analysed at the time. So as Alice Baum just presented to you, they've sent a legal memo which they've only just completed yesterday in time to get it into the court. So we've got new information, and this is not something that brings me any joy to continue bringing this sort of thing back to the committee, but very important that we keep you as aware as we possibly can of updated information that's coming through that is going to impact the budget, and that's what we committed to doing. Ms. Baum explained to you about the information that was in the memo, and part of that was that the court asks for appeal points to be grouped together that could be heard at the same time, different people coming together at once, and that's not always just one complete appeal. That can be grouped into all sorts of groups within that topic to get the same people who have some interest in the same points together. So it's quite a balancing act. But the court also asked for an indication of how long each appeal might take. And in the memo, an estimate was arrived at of about 82 days spent in mediation. So that is giving us a higher level of certainty, but was much higher, a much greater time commitment than we'd anticipated when we set the budget. We are looking at, as has already been explained, doing direct discussions with people and hoping that if some of those points can't be agreed to in direct discussion, that they can be heard together at mediation. Just hoping that some things might take a little shorter than has been estimated at this stage, but that's all part of the complexity of running this process. And we know what happened with the hearings, that they just take as long as they do. And also into the mix here is that the court granted 3 extensions to the appeals and 274 processes. So we had anticipated that we would start the mediation process in March, and yesterday the court confirmed that they wouldn't be able to start until at least May. So that's just pushing more of this process into the 2027 financial year than we even thought last year. So from an estimated 3 to 4 weeks, now we're looking at up to 16 weeks. Even more, could be less. We just actually don't know until we get started on the process. And I've said 12 weeks here, which I think was a slip of the finger because I've referred to 13 further down. So 13 weeks would occur in the 2027 financial year if we're lucky enough to get 3 weeks done in May now that it's starting then. So I've given you a rough estimate of the daily costs. That spread is between having your TTPP staff and lawyers there, or having an additional or a different principal planner on board for us. And then when we consider having experts to at least 4 of the mediations, and they could be week-long mediations because we'll need the experts for the tough things, that a daily rate can escalate up to $7,000 to $8,000 a day. So we are waiting to see this schedule, and the court only mentioned yesterday to Alice that they probably won't set the schedule for the whole thing. They'll give us the first couple of months maybe to start with, so they'll even be working in chunks. So we'll work with the information that we have and continue to keep you updated, of course. But in the meantime, our recommendation is that we increase the proposed 2027 budget for TTPP expenses now, while we can still get it in the annual planning, so that we're working to something far more realistic than we would if we had absolutely no certainty about how long this process was going to take. So when I've done some calculations on the 13 weeks, if it had been at this high rate, it would have been far more. But considering that some of the staff time is already accounted for, that we would have been working for you anyway, I am recommending that additional costs for 13 weeks of mediation would be about $290,000 added to the current approved 2027 budget expenses only. We still don't know what the income will be for those. So I've shown you exactly where I think those changes will be, and they're the things that I discussed with you when we were talking about the budget, that these are completely determined. Legal costs, consultants and planners, and the travel is completely determined by how many days and weeks these mediations will take place.
Okay, thanks.
A question.
Thanks, Joe. Yeah, questions. Councillor Gibson, I think.
Joe, are these daily costs just the norm? I'm horrified with how much they are, and we don't know how long it's going to go on for. But
yeah,
is this just an average cost of what happens?
It is, but I wouldn't even think it was average. I think it would be on the low side. I don't know what people around the table would tell you they'd be paying for consultants, but the consultants that we engage, and ourselves sometimes as consultants, are not by any manner of means in the medium to high end of payment. We're always trying to do the best for the finances on the West Coast. Experts are a different matter, Councillor Gibson. When we need someone from NIWA or a noise expert, we'll be paying twice as much in an hourly rate for them. But
in the early days, we put a budget aside for expert witnesses, which was only $50,000. Is that correct?
The experts are actually all part of the consultant planner contractor budget. So that was $450,000 for all of that.
All of it.
Yes, so they were part of that because they'll be consultants or contractors. So,
still horrified, thank you.
I know, that's why it's hard to bring this information to you, but I'm sure that there will be many other processes in many other places that would tell you that you'd be more than horrified with what they have to pay as well.
Thank you, Joe. Councillor Maitland, was it with a question?
Yes, I'm just wondering if appellants are successful in their appeals, can they claim costs if they're successful?
I am looking for our legal counsel. She doesn't appear to be there. My answer would be to say no, not costs on this, but Lois.
Yes, sorry, this was a question or a matter that Alice did cover at the last committee meeting. So it's not normal for costs to be able to be awarded against councils for plan making processes. So I think we can be reasonably confident, though nothing is 100% certain, that costs wouldn't be awarded against. I mean, the only way in which it might be. Alice might be coming back online to answer that question, but I think that it's kind of if for example the plan contains something that was just completely out of the kind of scale of what is normally in an RMA plan, that might be some grounds for the appellant to try and get costs, but we're certainly reasonably confident that that's not the case, and no one suggested that the plan contains anything that's sort of beyond what might be in an ordinary district plan. But I don't
Thank
know,
you.
Alice, if you wanted to add to that at all.
Alice, there was a question about could costs be awarded against the committee if appeals are successful? We've
right.
said no.
Yeah, no, it's a very remote possibility, but it's very, very unlikely in these planning processes that costs are awarded against the proponent of the plan, which in this case is the committee, because it would just be unfair, because we have to do that. We have to go through this process. We have to be a respondent to appeals. It would be incredibly unfair if we were then burdened with everybody's cost applications as well.
Thank you. Other questions on this paper?
Mr. Chair, may I just finish with point 12 that I had pointed out these 3 items are going to be the ones that are always going to have the budgetary risk because they're out of our control, and that even bringing this information now is still only going to cover part of the process, and there's still uncertainty around these particular items, and I will just keep updating you.
Yeah, thank you. Yeah.
Mr. Chairman, I wonder if it might assist if I could just paint a picture. I would like to think that you'll think that this is 82 days of 8 hours a day sitting in front of a commissioner mediating. Heading into a mediation, there is a good deal of time pre-hitting the mediation room and mediating with the other parties in front of the commissioner. So there's a whole bunch of prep time going into the mediation, establishing your positions and those sorts of things. Then there's the mediation time actually in the room. And then post that, there is, after that, there's usually a lot of work done drawing up the memorandums and other documents, hopefully getting the agreements signed off and done and off to the court. So let alone any other expert advice that might need to be commissioned as part of the mediation. So just really want to make sure you understand it's not 82 days, 8 hours a day in the room mediating in front of the commissioner. The other thing in terms of these costings as well is, if you can imagine, let's just say that we've laid down 5 days of mediation, let's just say at Shantytown, which is a common venue that they've done mediation before for the Environment Court because of the size of the room there. We've got to actually pay to bring everyone across from Christchurch or Wellington or wherever they are, and then pay for their time while they're here, and then get them back again. So there's a certain amount of fixed cost in there as well. Thanks.
Yeah. Thanks. That's helpful, Darryl. Thank you. Other questions or comments? If not, I'll turn to the recommendations in the late paper that the committee receive the item and that the TTPP committee approves an increase of $290,000 to the 2027 budget to account for up to 13 weeks of anticipated and additional mediation meetings. Someone to move that, please. No one's very keen.
No.
Moved. Moved, Chair Smith, thank you. Seconded by?
Yep.
Yeah.
Reluctantly.
Thank you, Councillor. All in favour? Aye.
Aye.
Against? Carried. Thank you. Thanks for your work, Joe, and the committee's work on receiving that paper and dealing with it. I think that concludes the agenda items. I note the next meeting's on the 10th of April at the Regional Council offices. So I'll close the meeting at 9:46, just giving us 10 minutes or so to have a quick coffee before we reconvene at 10 o'clock. I'll just mention that when we do reconvene, the first item on the agenda is to move to public excluded. So we're briefly in the public meeting at 10 o'clock and then we'll move to public excluded. But with that, I'll close this meeting. We'll see you at 10 o'clock. Thank you.
No, leave it to it.